If you're a green card holder and you filed your taxes this year, or you still haven't filed yet, I want you to stop whatever you're doing right now and watch this video all the way through. Because what I'm about to tell you isn't just tax advice, it can change your life. In 2026, there are 5 specific tax mistakes that green card holders are making, and these mistakes can cost them their permanent resident status, block their path to citizenship, and in the worst case, trigger deportation proceedings. These aren't hypothetical risks. Immigration attorneys across America are seeing real clients whose cases were lost for one simple reason. They made small mistakes that could have been easily avoided. And listen, these weren't criminals. These were hardworking, tax-paying, law-abiding people who just filled out one form wrong or missed one box. And that one wrong step destroyed years of effort. So in today's video, I'm going to walk you through all 5 mistakes, one by one. I'll explain why they're dangerous, what the consequences are, and most importantly, what you can do right now to fix them. Stay until the end, because the 5th mistake is the one most people are making in 2026, and it involves something in the new 2025 IRS Form 1040 that most tax preparers are missing. Let's begin. First, it's important to understand why the environment in 2026 is so different from previous years. By April 2026, the relationship between the IRS and immigration authorities has fundamentally changed. On February 24, 2026, a federal appeals court in Washington, D.C., ruled that the IRS can share certain taxpayer data with ICE. Along with that, USCIS has tightened its review of tax records during naturalization interviews and green card renewals. And on April 1, 2026, a brand new USCIS policy went into effect that allows immigration officers to consider FBAR and FATCA non-compliance when evaluating good moral character. What does that mean? Your tax return is no longer just a financial document. Now it's an immigration document, and one mistake on it can end years of lawful presence. Now let's look at the 5 mistakes. This might sound strange, but you'd be shocked how many permanent residents think they don't need to file because their income was below a certain amount, or their income was earned outside the US, or they didn't work for part of the year. That belief is completely wrong, and it can destroy your immigration case. For tax purposes, the IRS treats green card holders just like US citizens. That means you are legally required to file Form 1040 and report your worldwide income, not just US income, but every dollar you earned anywhere in the world, including foreign rental income, interest from foreign bank accounts, overseas business income, or any other source. For the 2025 tax year, the standard filing thresholds are $15,750 for single or married filing separately and $31,500 for married filing jointly. If your gross income is below these amounts, you may not owe tax, but immigration attorneys strongly recommend filing anyway. Because USCIS looks at your tax filing history when you apply for naturalization, renew your green card, and even during routine encounters. Every missing year is a gap, and gaps raise red flags. At a naturalization interview, a USCIS officer will review your tax transcripts for the statutory period, typically 5 years for most applicants, or 3 years if you got your green card through marriage to a US citizen. If a year is missing, the officer will ask why. If the explanation isn't convincing, your application can be denied on good moral character grounds. Good moral character is a legal requirement for naturalization. USCIS treats tax compliance as a direct reflection of it. Now, penalties. If you don't file, the IRS failure to file penalty is 5% per month, up to a maximum of 25% of unpaid taxes. If the failure was willful, it's a misdemeanor, up to 1 year in jail and up to a $25,000 fine. A criminal conviction for tax evasion is considered a crime involving moral turpitude under immigration law, which can make you deportable. In 2012, the U.S. Supreme Court ruled in Kawashima v. Holder that filing a false tax return can be an aggravated felony for immigration purposes, grounds for deportation. If you have past unfiled returns, don't panic, but act now. Use the IRS Streamlined filing compliance procedures. This allows you to file 3 years of delinquent returns and 6 years of delinquent FBARs and certify that your failure was non-willful. Getting compliant before any immigration filing is critical. This mistake catches green card holders from almost every country, and it's far more dangerous in 2026. If you have any bank account, savings account, pension, mutual fund, or any foreign financial account outside the U.S., and if the combined total of all those accounts exceeded $10,000 at any point during the year, you are legally required to file an FBAR FinCEN Form 114. This is separate from your tax return. It's filed electronically through the BSA e-filing system. The deadline is April 15th, with an automatic extension to October 15th. In addition, if your foreign financial assets exceed certain thresholds, $50,000 at year-end, or $75,000 at any point for single filers, and $100,000 at year-end, or $150,000 at any point for joint filers, you must also file FATCA Form 8938 with your federal tax return. FATCA requires detailed reporting of foreign assets, bank accounts, investment accounts, foreign stocks, and interests in foreign entities. Why is this so important in 2026? Because on April 1, 2026, USCIS implemented a new policy that lets immigration officers treat FBAR and FATCA non-compliance as a factor in good moral character determinations for naturalization, N-400, adjustment of status, green card renewals, and more. Before, FBAR and FATCA were only IRS issues. Now they are immigration issues too. Let's talk penalties. Non-willful FBAR violations can be penalized up to $16,536 per report. Willful violations can be up to $165,353 or 50% of the account balance, whichever is higher. Criminal penalties can include up to $250,000 in fines and up to 5 years in prison. Here's a real-world scenario immigration attorneys are seeing. A green card holder from India has a savings account and a small mutual fund back home. The combined balance hits $12,000 at one point in 2025. FBAR is triggered. They don't know about FBAR, they don't file, and then they apply for naturalization. At the interview, the USCIS officer asks about foreign accounts. If the applicant lies, that itself is a good moral character violation. If they tell the truth, the officer can now use the April 1, 2026 policy to weigh the unfiled FBAR against the application. Solution: file now. If your FBARs are late, use Streamlined filing compliance. And if your naturalization interview is coming up, immediately brief your immigration attorney. This isn't about whether you file, it's about how you file. Many married green card holders file as married filing separately. From a tax perspective, it's legal. But from an immigration perspective, especially if you got your green card through marriage, this can be a disaster. When USCIS reviews a marriage-based green card case, they look for evidence the marriage is real. Tax returns are some of the strongest evidence. If you and your spouse file separately year after year, it's a red flag. USCIS may interpret it as you not sharing finances, not living together, or the marriage not being genuine, combined with other factors, separate leases, separate bank accounts, limited photos. Separate filing can contribute to a finding that the marriage was for immigration purposes. Result: green card denial, conditional residence revoked, or removal proceedings for immigration fraud. Immigration attorney Sekou Clark has specifically said green card holders should not have a random tax return saying they're married, but filing as single or showing separate leases. Consistency between your tax filings and immigration filings is extremely important. Now, the second dimension of this mistake. This is not just marriage-based cases. If your tax preparer filed your return on Form 1040-NR, the non-resident alien tax form, instead of Form 1040, you have effectively handed the U.S. government a document saying you are not a U.S. resident. For a green card holder, that's catastrophic. Filing Form 1040-NR When you have a green card signals to USCIS that you may have abandoned permanent residency. It doesn't matter if you didn't intend it. It doesn't matter if your tax preparer made the mistake. That form is an official government document, and the position it takes becomes part of your immigration record. Form N-400, the naturalization application, specifically asks whether you have ever claimed to be a non-resident on a U.S. tax return. If a 1040-NR appears on your transcript, the answer becomes yes, even if you never meant it. If your preparer filed the wrong form, file an amended return using Form 1040X immediately. Request your IRS tax transcript to see exactly what immigration authorities will see. Fix it before your next immigration filing. This mistake isn't about filing incorrectly, it's about what happens after you file. Many green card holders file their return, discover they owe money, and then do nothing. They don't pay. They don't set up a payment plan. They ignore notices. They assume that because they filed, they are in compliance. They are not. Owing taxes does not automatically create immigration consequences. USCIS does not deny green cards or naturalization just because someone has a tax balance. But here's the danger. USCIS looks at the totality of your tax history. If you owe a significant amount and you've made no effort to address it, USCIS can treat it as a negative factor in your good moral character analysis. The logic is simple. If you have a legal obligation and you willfully ignore it, you aren't demonstrating the responsibility required for citizenship. It gets worse if IRS enforcement escalates. If you ignore your tax debt long enough, the IRS can file a federal tax lien, levy bank accounts, garnish wages, and in extreme cases refer the case for criminal prosecution. A conviction for tax evasion is a felony, up to 5 years in prison and up to a $250,000 fine. Under immigration law, tax evasion is a crime involving moral turpitude, and a conviction can make a green card holder deportable if it occurred within 5 years of admission. Even without a criminal conviction, large unresolved tax debt can trigger public charge concerns, especially when combined with low income, limited work history, or public benefits. Solution: set up a payment plan with the IRS now. The IRS offers short-term payment plans for balances under $100,000 that give you 180 days, and long-term installment agreements for larger balances that can allow up to 6 years. You can apply online at irs.gov. Having an active payment plan shows USCIS you understand your obligations and are taking responsible steps, infinitely better than ignoring the debt. If you owe back taxes for multiple years, consult a tax professional before your next immigration filing. Set up a plan, make some payments to build a compliance record, then proceed with immigration applications. This is the mistake catching the most green card holders off guard right now, and it's connected to a change on the 2025 Form 1040. The IRS updated Form 1040 and added a small but critically important checkbox, asking whether the taxpayer and spouse were present in the United States for more than half the tax year. In other words, more than 6 months in 2025. When checked correctly, it signals that you are claiming U.S. tax residency. The problem is that it's very easy to miss. It's small, tucked into the form without dramatic emphasis, and many tax preparers, even experienced ones, are overlooking it. When the box is left unchecked, the return represents you as a non-resident for that year. And as I explained earlier, representing yourself as a non-resident while holding a green card directly contradicts your immigration status and can be treated as evidence of abandonment. Immigration attorneys are already seeing this with real clients. People who lived in the U.S. all year, paid taxes, followed every rule, and their accountant simply missed that one checkbox. When those clients request their IRS tax transcripts, the transcript shows them listed as a non-resident. Those are the same transcripts USCIS reviews in naturalization interviews and green card proceedings. Form N-400 asks 2 specific questions directly connected to this issue. First, have you been outside the U.S. for more than 6 months? Second, have you ever claimed to be a non-resident on a U.S. tax return? If your 2025 return reflects non-residency in IRS records due to this missing checkbox, the answer to the second question becomes yes, even if you never intended it. Best case, intense scrutiny. Worst case, naturalization denial. Review your completed 2025 tax return carefully and find that U.S. residency checkbox. If it's blank, contact your tax preparer today. Request your IRS tax transcript to see exactly what government records show. If the transcript incorrectly reflects non-residency, file an amended return using Form 1040X as soon as possible, before any immigration filing, naturalization interview, or international travel. The elephant in the room in 2026, IRS and ICE data sharing. Now let's address the elephant in the room that makes all 5 mistakes even more dangerous in 2026. The IRS and ICE entered a data sharing agreement that has been the subject of intense legal battles. In April 2025, the Treasury Department and the Department of Homeland Security signed an agreement allowing ICE to request taxpayer data from the IRS, specifically names, addresses, and filing years, for people with final removal orders or under criminal investigation. ICE submitted about 1.28 million names to the IRS. The IRS matched about 47,000 and shared some address data. The agreement was so controversial that several top IRS leaders, including the acting commissioner and chief privacy officers, resigned. They argued the deal violates Internal Revenue Code Section 6103, which has protected taxpayer privacy since 1976. By April 2026, the legal situation is complicated and contradictory. In November 2025, a D.C. judge blocked the IRS from sharing more addresses. In February 2026, a Massachusetts judge issued a broader order, blocking ICE from using data it had already received. But on February 24, 2026, a D.C. appeals court declined to block the data sharing. The case is expected to go to the Supreme Court. As of March 17, 2026, federal court injunctions technically prevent the IRS from sharing taxpayer data with immigration enforcement. But the legal landscape is shifting, and there's no guarantee these protections will remain. For green card holders in good standing, the IRS-ICE agreement is not directly aimed at you. It's focused on people with final deportation orders or criminal investigations. But the broader lesson is unmistakable. The wall between your tax records and immigration records has never been thinner. Errors, omissions, and inconsistencies in tax filings can now surface in immigration proceedings in a way that was never possible before. Exactly what you should do now to protect your green card. Here is exactly what you need to do to protect your green card. First, and most urgent, review your 2025 tax return for the residency checkbox. If it's unchecked, contact your tax preparer today and file an amended return if needed. Verify using your IRS tax transcript. File all outstanding tax returns immediately. Use the IRS Streamlined filing compliance procedures, 3 years of delinquent returns and 6 years of FBARs, before any immigration filing. Check your FBAR and FATCA obligations. If your foreign accounts combined balance exceeded $10,000 at any time in 2025, file FinCEN Form 114 by April 15, 2026, or rely on the automatic extension to October 15, 2026. If FATCA thresholds are exceeded, file Form 8938 with your tax return. If you owe taxes, set up an IRS payment plan now, online at irs.gov or by phone at 1-800-829-1040. An active payment plan helps show good moral character. Review your filing status. Filing married filing separately? Talk to both a tax professional and an immigration attorney. Marriage-based green card? Filing jointly is almost always a stronger position. Confirm your preparer filed Form 1040, not Form 1040-NR. Wrong form filed? Amend immediately with Form 1040-X. Brief your immigration attorney on your full tax history. Raise the April 1, 2026 FBAR policy and the Form 1040 checkbox change proactively. Find a tax professional who understands immigration consequences, a CPA or enrolled agent specializing in expat or immigrant tax preparation. In 2026, the U.S. immigration enforcement system is more connected to the tax system than at any point in history. The IRS ICE data sharing agreement, the new USCIS FBAR policy, the updated Form 1040 residency checkbox, and the Trump administration's denaturalization program all combine to create an environment where every tax filing is also an immigration filing. The green card holders who will be safest in this environment are the ones who treat every tax filing like an immigration filing. Every form, every checked or unchecked box, every filed or missed return builds a record that USCIS, and potentially ICE, can review. You can't afford to be careless. You can't afford a tax preparer who doesn't understand immigration. And you can't afford to wait. The good news is that every one of these 5 mistakes is fixable. Unfiled returns can be filed. Missed FBARs can be caught up through streamlined procedures. Wrong forms can be amended. Tax debts can be put on a payment plan. And that checkbox can be corrected with a 1040X. But the window to fix these issues gets smaller every day, especially if you have an immigration filing or interview coming up. So take action today. Not tomorrow, not next week. Today. File your returns. File your FBARs. Check the box. Set up the payment plan. Meet an immigration attorney. Talk to a tax professional who understands immigration. If this video helped, hit the like button, subscribe to the channel, and share it with every green card holder you know. Comment below which of the 5 mistakes surprised you the most. I read every comment and I do my best to answer questions. Stay informed, stay compliant, stay safe. See you in the next video.